Hi, everyone. Thank you for joining us at this panel about certification and case management. I'm Lori Kovach. I'm a Senior Vice President at Epic. We are a global legal services company. My division specializes in collective proceeding certification and settlements. We handle cases in the US, here in the UK, in Canada, and in other European countries. I have a great panel here today to talk about this topic. I'm going to let them introduce themselves, starting with Adam.
Hey, nice to see everybody. My name is Adam Polk. I'm a partner at Gerard Sharp. We are a San Francisco-based law firm representing primarily plaintiffs in class and mass proceedings. I personally focus my practice primarily on securities, financial fraud, consumer, and privacy cases.
Amir?
Hi, great seeing everyone. Amir Nasihi. I'm a partner at Shook, Hardy & Bacon. I'm based in their San Francisco office. It's a Kansas City headquartered firm. I work primarily in the class action side at Shook, and most of my work focuses upon defending product manufacturers, distributors, sellers in consumer class litigation.
Dan?
I'm Dan Williams. I'm a partner at DWF. I've traveled all the way from Manchester, so no real competition there. So I'm a partner in the dispute resolution team, do general commercial corporate litigation, but a side piece to that is defendant class action work, notably acted for British Airways in its defence of the GLO data breach. And we have various other claims that are ongoing pre-action.
Great, thanks. So we're just going to start off with a quick summary of collective and class proceedings in our two jurisdictions represented here. So Dan, if you want to go ahead and get started.
Yeah, I had the unfortunate part of Justice Waxman this morning talking about case management and GLOs, which is what I'm now going to talk to you about, and I'm going to try and do a better job than the judiciary of explaining how GLOs work within England and Wales. So to the extent that I can trump Justice Waxman this morning, I'm just going to talk and give some anecdotes, really, which obviously we didn't touch on this morning in terms of how the process works here in England and Wales. So I'm going to concentrate primarily on group litigation orders. So I'm sure many of you will be aware there's various mechanisms within England and Wales by which we can issue collective and class actions. As the civil procedure rules has the group litigation order and the collective proceedings, which most people know as a result of Lloyd and Google is not the favoured model at the moment. And then the alternative aspect is those claims that proceed through the Competition Appeals Tribunal, which I won't be speaking specifically on. As I say, I'm going to concentrate on group litigation orders. So just very briefly, really, how a group litigation order is instigated, what happens at the GLO hearing, so the group litigation order initial hearing, and then we move on to case management. So that first stage in the group litigation order process is that GLO order hearing, and as I say, that is where the group register is established, the rules governing who can join the group register, which claimants can join the group register, and also establishing what the GLO issues are. So we heard Waxman this morning talking about how quite a difficult process in the diesel emissions claims was actually agreeing between the claimants and defendants what the GLO issues were. Some cases it might be relatively straightforward. So for example, just to mention the British Airways case, fairly straightforward issue as to whether or not a particular claimant was adversely impacted by the data event. Obviously, very more sort of technical issues in the Dieselgate litigation. Also considered at that initial phase is the appointment of the lead solicitors and a steering committee. So this is where you might ordinarily have the first jostling match between the plaintiff claimant solicitors to, who's got the most claimants, who's got the biggest cohort, who's the bigger, better law firm, all that kind of jostling goes on so that the lead solicitor is appointed, and that's obviously quite important for the claimant solicitors because they're the ones that will be driving the litigation, and as a result will be incurring the costs and driving those costs on behalf of the class. So there was a sort of a separate issue just on the, this is because of some relatively recent case law on this question of to GLO or to not GLO. And as I say, we heard from Waxman this morning that actually there is, I wouldn't say a sea change, but GLOs are not predominantly particularly, I wouldn't say attractive, but pursued in England and Wales. And there's only been 112 of them since the instigation of group litigation orders in 2000 in any event. So only 112 claims that have actually been issued. And we're starting to see, certainly in the data space, that the courts are shying away from actually ordering a group litigation order and moving away from claimant firms being able to establish a group register, not having a need to go and claimant farm in the same way that they have previously. As I say, there was 2 cases for any of those that are interested in case law and want to read it tonight maybe. There was the Edward and Moon case and the Beck and the Police Federation of England and Wales, which was just earlier this year. As I say, in those cases, the court preferred the defendant's argument that the group can be appropriately represented just by one test case, and that there was no need for a group register of all of the claimants to be established, which cuts out a very significant element of the costs that can be incurred in the establishment of the group. I'll leave boring people with group register for now.
Sure. So I think we're going to just contrast that with the U.S. regime, which I think most people in here are familiar with. But Adam, you want to start with that?
Sure. I think in preparing for this panel, what struck me as kind of shocking was how early in the proceedings the GLO hearing happens. I think there's probably a lot of familiarity in this room with how it works in the United States, but I think Amir would agree with me. We have most of our class cases are conducted on an opt-out basis, so we may represent, a handful of plaintiffs, and then of course we propose to certify them. Just because you file a class action doesn't mean it's certified until you win a motion to certify, and that can have, dramatic consequences for both sides, because you go from having 4 to potentially, hundreds of thousands or over 1 million claimants. And so, it kind of struck me listening to Dan preparing that the UK is kind of, 30 years behind, where we are today. I looked up modern Rule 23, and it looks like the big amendments were in 66, so it may be closer to 50, 58 years behind us. But at any rate, really the merits and the class issues have merged over the years due to a string of Supreme Court decisions. Class certification is still procedural in nature, but it's not a rubber stamp. You need to produce evidence, and these days, I heard somebody earlier talking about how at class certification you can, put on a damages report that says, hey, it's possible to prove damages on an aggregate basis. I think if I did that in a case opposite Amir, I could be in some hot water. So it's, these days you're really having to run your whole method, run your survey, do your conjoint. It still varies district to district, but I think it's a best practice to do that. So I think the initial case management is conference is quite different. I think in a lot of my cases, I may only see the judge twice over the life of a case. Once at the initial CMC, once at the settlement approval hearing. So I think the judges, I do primarily work in federal district court. They're very sophisticated. They're completely clear-eyed about the consequences of certifying a class on a defendant or not certifying a class for the plaintiffs. So you can't go into that initial conference and go through the motions. I think the expectation rightfully from the bench is that you're going to have thought about your case. Justice Waxman said, cooperation, common sense, core issues, you're going to have those identified at that initial conference. And I've been asked by federal judges at the initial conference, Mr. Polk, I'm sure you've already, written your jury instructions. Of course, I hadn't when that happened. But I think it speaks to the expectation from the bench.
Yeah. Amir, any thoughts from you on the distinctions there?
Yeah, I would just echo Adam's comments there. I think it's very much a focus of a class certification hearing is a rigorous analysis, and that, like Adam says, goes back to a series of Supreme Court cases, really the Walmart v. Dukes being the predominant one. And really that's because the class certification hearing is the be-all or end-all of the case. If you win class certification, then most cases will at that time resolve. There's just too much of a potential exposure there for many defendants to carry on and take the case to trial, although we're starting to see more and more cases progress toward trial, and we'll talk about that a little bit later. But at the same time, if class certification is denied, the case is essentially over. Unless the Court of Appeal grants review, which is discretionary, the case is really not going to proceed to trial as an individual case. So that initial CMC is something which we do put a lot of focus toward. Like Adam said, it's rare you go see the judge more than a couple of times. That initial case management conference is one of the key times where I've worked with Adam's office on preparation for case management conference. It's always very thoughtful, practical, workable solutions, and you kind of try and obviously steer things in the way you think makes most sense in what you present and propose to the court. But it really is a very kind of important event in the lifetime of the case.
Yeah. And to expand on that a little bit more, I think a lot of the distinctions really come in around what discovery or disclosure is or isn't taken at that early stage in the case. Dan, when you were talking about establishing the GLO schedule, I know you mentioned that claimants have to fill out certain types of questionnaires, but there's not really any disclosure conducted otherwise aside from that. Do you want to talk more about that or the lack of disclosure at that point and whether that impacts the process of the case?
Yeah, no, exactly. So it's that point really. As you have this certification process where you have that front end sort of kicking the tires of whether the case has got the merits to proceed or not. Whereas here, certainly under the GLO regime, there isn't that assessment at the early stage as to the sort of the merits of the case. There are opportunities available to a defendant if somebody's trying to issue a very unmeritorious claim to have it struck out early, so to have that assessment early. But assuming that the claim has some merit, the first opportunity that certainly any significant disclosure will be given will be during the course of the litigation. So after the close of pleadings, so the claimants will have already pleaded their claim without the benefit of certainly any extended disclosure. As I say, there'll be some rounds of pre-action correspondence where the parties will be, and certainly the defendant will be encouraged to give, sort of full and frank exchanges as to what the issues are by reference to certain documents. But it's not some, we heard Waxman this morning talking about the sphere of disclosure and how it reveals, many hundreds of thousands or millions of documents that need to be sifted through an e-disclosure platform. Well, that all happens long after the parties have set out what the nature of their claim is.
Yeah, and I think it's similar to the cases before the Competition Appeals Tribunal as well, right? You can get the collective proceeding order without any disclosure having been conducted as well. And that's quite the contrast from what Amir and Adam are seeing in the U.S. Either of you want to comment on that?
Well, your chin fell on the floor when I mentioned that.
Yeah.
Yeah, no, it's quite different. We have a statute called the Private Securities Litigation Reform Act. It was enacted in 1995, and that governs securities, fraud, omission type class actions generally. There's a mandatory stay of discovery in those cases. Other than those cases, though, unless the defendant moves for and prevails on a motion to stay discovery, discovery is open from the inception of the case. That being said, I go back to what Justice Waxman said at the beginning of the case, use common sense. If you go in there, after you filed your complaint, the other side has moved to dismiss, it happens in almost every case, dismiss all the claims, and you say, okay, it's open season, we want all ESI that the defendant has, which could shift a significant burden to the other side, I think you'll, more than raise an eyebrow almost uniformly across the courts. I think on the other hand, if you're more thoughtful about it, if you say, okay, we don't want to be starting from zero once we get the order, we should get our confidentiality agreement in place, we should get our ESI protocol in place, and hey, Amir, tell me about what burden this specific document request imposes on your client, because I think it'll be useful to identify third parties and focus other discovery. I think that's when the defendant has a tougher time saying, okay, no, nothing now, not ever. So that's generally my view of it.
Yeah, no, I think Kevin makes a good point. Where you have plaintiff attorneys who come in with reasonable focus requests early on, it certainly is something that I think engenders cooperation. Whereas the flip side is if you have a plaintiff attorney who comes in with very expansive requests, although it's difficult to get a formal stay from the court, discovery does not open up in federal courts until parties conduct a Rule 26 conference, which is you sit down and you talk under Federal Rules of Civil Procedure, Rule 26, and you discuss key issues in the case. And the timing of that Rule 26 disclosure, it's statutory, but the reality is it's governed by the courts and when courts set the scheduling conference. So most times when you're facing class action, a defendant will file a motion to dismiss on the pleadings, challenge that initial complaint, and the court rarely sets that initial scheduling conference or case management conference until an answer has been filed, so until the pleadings have been settled. That can sometimes take up to a year. Occasionally it takes longer depending what federal court you're in. And so the defendant does have the ability to defer when you hold that Rule 26 conference to open up discovery until somewhere down the line when the pleadings are settled. But at the same time, if a plaintiff attorney approaches and talks about a reasonable, practical, workable plan to do focused discovery, it's a lot harder to kind of defer discovery to that point. You're kind of motivated to talk to each other, cooperate, and get those initial steps of early discovery done and disclosures accomplished.
You guys can all hear that Amir is a very capable advocate. The way he's very reasonable sounding, everything is logical, but he is an advocate. I think the rule does still say do the 26F conference early, so I always press to do it early for the reason that I said. I think any capable defense lawyer will do what Amir is saying, push the Rule 26F conference off, because otherwise you open yourself up to discovery. But I think that you really, my view is you kind of owe it to your clients to try to get the 26F conference done early. I think in preparing for this, somebody said that each judge runs their court like a fiefdom in the U.S., and it's really true. So each judge has their own standing order, has their own procedures, has their own protocols, has their own kind of law of the courtroom. So you really need to kind of look and see, how does your judge operate? Do they do what Amir said? Do they only set the initial conference after the pleadings are settled, or do they do something else and then advocate accordingly?
And Amir, as a representative of defendants in the U.S., what do you think of a regime where you would get to see questionnaire information about everybody signing up on the claimant side before they conduct any discovery at all?
I think that would be terrific. The reality is, I think most of the class actions that we get have a very small number of named plaintiffs. Now, we do have a procedure for initial disclosures in the United States. Those really don't provide much information. and it doesn't really come with mandatory document exchange. You can just generally describe documents and categorize them without producing them. So something with a little more teeth in there initially, even if it's for a smaller number of plaintiffs and what you'd have in the UK, I think would be very helpful to just kind of set the stage early on.
So I think one of the implications of when and how disclosure or discovery is conducted is costs. But there's quite a bit of difference in the regime regarding costs between the UK and the US. So Dan, do you want to talk a little bit more about that?
Yeah, absolutely. Yeah, we were talking, obviously in preparation for this, about the fact that there's a sort of an ability for over here for the successful party to recover their costs from the unsuccessful party, and that could be the defendant. You know, it could be that the defendant is successful. And again, Adam was, aghast that there's a situation where the defendants, where the claimants might have to put their hand into their own pocket and pay any adverse cost award, because that isn't the case in the US. But the whole regime around costs within a group litigation order, which is dealt with at the first case management conference, which comes after the GLO hearing itself. There's a whole cost management process. So lots of those people in this room that are familiar with litigating in England and Wales will be familiar with the cost budgeting regime, and that's a process that we went through on the British Airways case, where both the claimant and the defendants are required to present to the court and try and agree beforehand, which is impossible because everybody's very far apart, / the claimants are very unrealistic. So they present their budgets for each phase of the litigation, so from pleadings, witness, disclosure, experts and trial. In this case, a bifurcated process, i.e. a trial on liability only. So as I say, the expectation is that you'll either try and agree those costs, and to the extent that you can't, you have that discussion or argument in front of the judge. And on that particular case, that argument lasted 3 days. It was a 3-day cost and case management conference. So we were all pretty tired by the end of it, of arguing pounds and pence on how much people should be able to recover. The sort of difference for anybody that has gone through a cost budgeting process here already is that in the GLO context, the costs are split. So there's what's called common costs and individual costs. So common costs are those that are incurred by the claimant, solicitors, doing anything and everything that's common to the class, so the pleadings, instructing the expert, reviewing the disclosure that's provided by the defendant. But then there's an element called individual costs, which are the costs that the claimant law firms will incur onboarding a client, advising a client throughout on an individual basis, and at the end of the case or at any settlement in terms of administering any settlement proceeds. So there's a process to try and agree how much the claimant law firm should be able to recover per capita, as it were, so per claimant for each claimant that they have. And that, in that particular case, was quite a hot topic. The claimant law firms, this is all public information, the claimant law firms wanted circa £1,900 for individual costs, so that's just a set sort of fee or a figure that the claimants would recover per claimant. And in a potential class of 500,000 claimants, I haven't got my calculator with me now, but I think it was £800 million could be incurred just on essentially onboarding clients. So there was quite a, as I say, hot debate about the level of costs that was being sought, the work that was being generated for those costs, and then in the end, those costs were significantly capped by Justice Saini, who was the managing judge, to a far more modest figure. I think it was 300 odd pounds per claimant, which multiplied by 500,000 is still a very significant number, but a lot less than what the claimants were.
Dan, when in the case does that discussion happen?
That's a close of pleadings, so before you really get into the, witness statements, disclosure, expert evidence, etc. So that happens very early on, yeah. So that there's an understanding quite early in the proceedings as to the exposure that let's have it right, I guess, that the defendants are likely to face if the class action proceeds beyond certain phases. You have an understanding of what the cost liability is very early on. As I understand, it's very different in the US.
Yeah, it's quite, I mean, it's the English rule versus the American rule, I think, is how it's referred to. I think the American rule is generally that's subject to exceptions that may be included in state statutes. Each party bears their own costs and expenses. And, so the way the economics work on our side, I said at the outset, you really have to front load your preparation, your trial preparation. In the case, you generally do not, draw a dividing line between class certification and merits discovery. At least I don't. So you do incur a lot of hard costs, a lot of attorney time, and we do everything on a contingent basis for the most part. And so if you're successful at the end of the day, you apply to the federal district court for a fee and reimbursement of your costs. These cases can pend, 5 or more years, and so you can accrue a significant amount of both fees and expenses. And so I think something that you're seeing more and more often, something that my firm certainly does, is at the inception of a case, prior to that first case management conference, we adopt something called the time and expense protocol, where usually these cases we partner with other law firms, and so it requires everybody to exchange their time. It requires, it sets forth certain categories of expenses that you can incur, certain categories that you can't. Provides for things like, if you're flying, fly coach or economy only, don't bill first class to the file. And as a best practice, what we've been doing across several of the cases is including in the protocol provision to share your time and expenses billed on a quarterly basis with the court. We've done that both in camera, meaning for the judge's eyes only, and we've done it on the record. I think on the record is more rare, but I think our view of it is that there's nothing to hide. It's hard work to litigate these cases. It's hard work to get the classes certified. I think if you're sharing with the judge and even the other side what's going on, it'll avoid surprise at the end of the day. There will be no sticker shock at the end of a 7-year case when you submit your fee application.
And have you ever had commentary from the judge or from opposing counsel when you do that?
The judges like it. It was funny. I had a case recently where we were appointed lead, and this is not a requirement anywhere, but we had implemented a time and expense protocol that provided for in-camera submission, and the judge thanked us, and he then asked for more detail than we were submitting. We were submitting summary time, and the judge wanted, task code and, biller, which was fine, so.
Yeah, and I mean, Amir, if you saw that in one of your cases, would you ever seek to comment or argue that maybe plaintiffs were spending too much money?
Yeah, I think it's a good idea. I haven't seen many firms do it. I've seen Adam's firm do it. I think it's an excellent idea. I have adopted it where in some situations where we work with the other side on interim class counsel stipulation for appointment and making sure that that's in there. In terms of time entries going to the judge for in-camera review, I'm not so sure how I feel about that. It depends what kind of narrative goes in there. That in itself can create an issue if it's just in camera. But yeah, I've seen similar orders where they go to a special master. I haven't seen them where they actually go to specifically to the judge, the federal judge at least, that's overseeing the case.
Yeah. Any other comments on costs? I think there's quite a bit of difference here when you're setting in caps and rules so early on versus the U.S. model where it kind of accrues over the life of the case.
Well, there's one more, one issue just Adam mentioned, kind of state rules. There's some states like California where if you're litigating in state court, there's some provisions where under a certain statute you can get all your expert costs. and those could be substantial. I remember one class action trial I was involved with maybe about 8-9 years ago, where it ended up being a defense verdict, and the expert costs that were imposed on plaintiffs were about $600,000. And those are significant because under that state statute, you get a lot of state class actions in California. Under that state statute, for the plaintiffs to then appeal, that costs award doesn't get stayed. And so you have to post a bond of 1.5 times that amount. And so it can be fairly potent, but that's really, I think, the strongest kind of fee provision that I'm aware of.
Yeah.
Or fee cost provision.
So one of the other big distinctions, I think, in the regimes is the difference in notification to the class. And so, Dan, I know you had some anecdotes from the British Airways case about
in terms of
claimant's request,
publicising and whether the defendant should be doing anything to help the class in terms of contacting its class members. I mean, the main point within a GLO that it's an opt-in regime, so the claimant firms are already at a sort of a disadvantage in that they need to go out and find the claimants and claim farms. So we had this instance at the outset and at the GLO hearing on the British Airways matter, where there was quite a reasonable discussion as to whether or not the defendant should be doing more to help the claimant law firms reach out to the class, because I think at that point only something like 2% of the available class had actually come forward and were clients of the various claimant law firms. So various options were mooted by the claimant law firms. So, for example, whether the defendant should email the same customer base that it sent the initial notification informing them of the data breach, to also say, hey, if you want to sue us, just contact this claimant law firm and they'll arrange for it, no problem. So that was a suggestion that was put forward by the claimant law firms, very, I would say, anti-British in terms of an approach. So that was quite quickly rejected. There were other methods, though, that were suggested, whereby perhaps the defendant should share more information with the claimant law firms to enable them to contact the class rather than have to do the hard yards in terms of advertising, social media, television campaigns. I mean, those in the room that live in England will have seen the various adverts for Dieselgate, data breaches. They're quite repetitive, but that's how they get the claimants through the door. And same again with social media campaigns. So there was this process within the GLO hearing as to whether the defendant should have to do more, and as I say, the outcome of that was a resounding no, and the only notice that was publicised is the one pursuant to the GLO regime and the civil procedure rules, that a notice goes on the Law Society website, which most people don't spend their time looking on the Law Society website to see which GLOs have been issued. So that was the extent to which the defendant was encouraged to assist the claimants, as it were.
And that makes sense, I think, in terms of an opt-in action, right? But even in the claims before the CAT, once the collective proceeding order is entered, even if the defendant has information at that time, they're not required to turn it over to plaintiffs or claimants' lawyers to help notify the class, which I think is much more of a contrast to what happens in the US, where that does have to actually take place.
Yeah, I think you put your finger on it. It's opt-in versus opt-out. I think the standard that we're held to in a 23B3, so a money opt-out class action, is best noticed practicable under the circumstances. And the reason is because you're concerned about the due process rights of the class members, because if you can give notice two ways. You can, either it's a litigation class where there's no settlement, you're litigating, you're running along, you get your class certified, and then notice goes out to everybody, and they get a chance to either do nothing, in which case they're hitching their wagons to the efforts of class counsel, or opt out and go their own way. Or you can do it, you often have what's called a settlement class, where a settlement's achieved before a class is certified. And so you concurrently have notice that, hey, there's a class action, and hey, you could get these benefits under this proposed settlement. Under both situations, I think the courts are, very concerned with absent class members' rights, and rightfully so, because in the latter situation, where say you get some certain of money in exchange for your release, if notice isn't good and widely disseminated, there's people who could be part of that class and release their claims without knowing about it. And so that's where firms like Lori's come in, settlement administrators. They have notice experts on staff who know how to get the word out about class actions and about their membership. And I think it's an important matter of due process. So it's just a different system.
Yeah. Amir, any further comments on that one?
I think that there's one type of class settlement which we've done where you don't give notice, you don't have to give notice, and that's a 23B2 injunctive relief settlement class, and that's where there's no money being disseminated, but it's typically some change of practice or some kind of labeling change, and even then, best practices tend to be to give notice, but that's a one kind of category where you technically don't have to give notice out.
Yeah. All very interesting and very different. So we just have a few minutes left. Do we have any closing thoughts from the panel on the topic?
Yeah, I mean, I think, I was saying earlier that I didn't want to sound too sort of anti-claimant, because as I say, I think that the experiences that I've had, and even, I mentioned certain cases earlier, in terms of courts moving away from a GLO regime instead of sort of a test case, again, sort of using the case management powers, I would say, to keep steering the English legal system away from, perhaps, we speak about the growth of class actions, which inevitably there are, but there has been, over the recent years, and certainly in recent months, various decisions, including the Packard decision that'll be, has been spoken about and will continue to be spoken about between today and tomorrow, where, we're still making it, I think, quite difficult for claimants and claimant law firms to get redress, which, as a defendant lawyer, is fantastic, but appreciate not for everybody in the room.
So I think at least Rule 23 that governs federal class actions in the United States is very well developed, and the federal judges we work with on those are typically very well versed in it. Where we do sometimes run into issues is obviously in state court, where there's very different standards there, both on discovery, both on how the class action should proceed and what the elements of it are. So most class actions I'm involved with end up being in federal court, but one of the interesting things that I do see now and then is where a state court judge becomes a federal court judge, and they try and adopt that same state court practice there. So I think we're in a very well-developed situation with Rule 23, but at least as to kind of newer judges, I think the judicial education process is important to go along with, and sometimes it takes a little bit of time to have that consistency across courts in the U.S.
Yeah. Adam?
Yeah, I think the U.S. system's been in place for a long time. The rules had the benefit of a lot of decisions. I think it's still changing every day. And I think what we're going to see more and more of in the U.S., which is kind of unsurprising to me, is class trials. I think they're happening across the states now. I think, they're showing the impact of having a plan to try your case from the inception. I go back to that early CMC where the judge said, you know, Mr. Polk, do you have your jury instructions written? It's a good idea to do that. What my firm does now as a matter of course is with our class certification motion, we submit something called a trial plan, which is what it sounds like. It's, you know, what are the claims that you're bringing? What's the common evidence? What's the order of proof? The things that you would do for an individual trial. They're not that much more complicated for a class trial. We have across the states, we have a series of statutes going into effect in data breach cases and other you know, privacy type cases where they provide for what are called statutory damages. These damages can be as much as $5,000 per claimant. Some would argue per violation. So those, you know, that kind of takes the individualized nature of damages out of it and creates a greater incentive for plaintiffs' attorneys to go out there and try their cases. I said earlier, Amir mentioned Dukes. We're being put through our paces in our class certification hearings. My partner a few years ago had to go and do a multi-day evidentiary hearing before a judge in Colorado in support of class certification. So if you're preparing your case that way for class certification, you know, class certification is just the beginning as far as I see it, if you can develop the expertise to go and try your cases. And it doesn't need to be some, you know, exotic 50-state case. You can try issues under the federal rules that materially advance the interests of all class members. So I think that's the next frontier, and I think it's an exciting one.
Yeah, and I think that's very similar to what's happening with the Competition Appeals Tribunal as well. I mean, you see the tribunal asking lots of questions early on about what a claims process would look like and what payments would look like and what claims rates would be, and sort of with a very high goal of claim rates. So I think that early preparation for all the stages of the case at that class certification phase is really going to be what we're seeing a lot of.
I should mention, I've mentioned trial plans, time and expense protocols. I do have example CMC statements. So if anybody wants any of those materials, just come up and ask me. I'll give you my card. I'm happy to share them with you.
Thanks. So we have a couple minutes left if there are any questions in the audience, and if not, we can wrap up. Oh, right here.
Yes, I wondered, if there's a case where, I don't think you mentioned it, where two parties are competing for certification of a class action, what does the jurisprudence say about who's likely to win that battle? I know we've had some in the UK, but I don't know if that's been a thing in the US where there's two different claimant groups who refuse to work together and are vying for certification. What's the jurisprudence saying about that now, please? And UK or US, really, please.
Yeah, I can feel that because it's more in my world. It doesn't happen typically at the certification stage. It generally happens earlier. So Dan's been talking a lot about data breach cases. Those are generally easy cases to identify and file. So it's not unusual to have multiple firms file at the same time. Depending on the volume of firms, you know, you may just agree to work together. If you can't agree to work together, there's a protocol in the rule for the judge to decide who is best able to serve as what's called interim class counsel. So prior to certification, the appointment would be interim in nature, and then at class certification, you ask to be appointed lead counsel. So the factors that the courts look to are, you know, the resources of the firm, the work that the firms have performed to identify the cases, familiarity with the applicable law. It's really kind of a beauty contest where the judge is put in the position to try to identify the group that's going to do a good job for the class.
Yeah.
You know, I would just add, sometimes the defendant can help address that issue early on where there's a likelihood that additional cases are going to get filed and there'll be that competition. And I've done this a few times, most recently just last week, where you'll work out a stipulation with one of the firms on this interim class counsel appointment and kind of submit that for the court's consideration because there's an expectation that other cases are going to get filed and as a defendant, you kind of want that certainty as well. And for that reason, oftentimes you'll see a nationwide class claim included in a class action. And historically, I used to challenge those. I don't really challenge them anymore at the pleading stage early, because you need that nationwide class claim so that if a case with a nationwide class claim is pending in Los Angeles, if another one gets filed in Massachusetts, you have some reason to transfer that to the same court, because otherwise you won't really have a basis or much of a basis to try and transfer that case in and try and get them consolidated.
Thanks. Any other questions?
I was wondering, if you are appointed as an interim lead counsel, then you can still lose the case after certification. Am I right in that respect?
That would be rare. I think, if I understand you right, are you asking whether like a competing group could come in at certification and take the case away? Yeah, that would be very rare. There would have to be something kind of catastrophic that happened, a conflict or some ethical issue.
I think time is up, so thank you very much, everybody.